SB18.
Senate Bill 18 by Senator Clark to amend the law concerning child custody and visitation.
Thank you, Governor. Members, Senator Chesterfield, Senator Rayford, if y'all will indulge me a few extra minutes. This is a very important bill, and there is nothing that we can do to fix custody cases that won't be fixed. Where we have mothers and fathers that want to use their children as weapons and psychologically abuse their children to try to hurt their spouses, ex-spouses, etc. We can't fix that. The courts can't fix that. There's all kinds of things we can't fix. But there are things that we can make better. And you have a handout that shows that the vast majority of the population prefers joint custody, and for good reason. It's not nirvana. It doesn't fix every situation. It's not for every situation. We passed a law in 2013 that said that the courts were to favor joint custody. The Judicial Council and the Bar Association both said that was good enough. Let me read to you from the Arkansas Circuit Court Judicial Bench Book, Domestic Relations, updated June 2018, from page 75. Now they updated, after our Judiciary Committee meeting Wednesday, they updated it again. What I'm going to read to you, this first part is still the same. In an action for divorce, an award of joint custody is favored in Arkansas per 9-13-101A. That was passed in 2013 by this body. However, case law, both before and after adoption of code provision above, indicates that joint custody is not normally favored unless circumstances clearly warrant such action. This is, I sponsored and ran, but we passed a law for relative placement when children are taken from their homes in 2015, but we already had a law. And we passed a new law because we had a judge that had a standing written order that any DCFS employee who placed with relatives was in contempt of court. And so we're frustrated by what do we have to do in order to pass a law that is a law, that is honored. They have removed this next part as of the weekend. Joint custody or equally divided custody of minor children is not favored in Arkansas unless circumstances clearly warrant such action. That's what's been there since 2013, even though the law said that we passed that it did favor such action. Now, what the Bar Association, who I greatly respect, and the Judicial Council, who I greatly respect, have said is that this law is too strong. I have met with the Bar Association for probably, I think our first meeting was close to 18 months ago. And up until today, they offered me nothing except a vote to oppose. After we passed this bill through Judiciary Committee 7-1, I called them again and said, if you really think this is too strong, write something that isn't too strong. I said, I don't care if you tear it up and start over. They finally sent me an amendment a little while ago that I have not read yet. I will look at it. I will sit down with them. And again, if this language is too strong, we will work with them. We will work with Judicial Council. I have been trying to work with them all the way through. One of all the attorneys that they had call you, many of you had them call me. Some of us even had conference calls. Every attorney that called from the Bar Association favors this law being stronger, and was not aware that I had been working with the Bar Association or that the Bar Association had opposed this up until now. One dad they had call, many of you would know, professional who was afraid that this would cause him to possibly lose custody. You know, and I said, you know, you're the exception. I said, for you, there are 10, for every one of you, there are 10 dads that have a different story. And he said, no, Senator Clark, he said, for me, for every one of me, there's 100 dads. He said, I'm a unicorn. I have been about doing the right thing for children and families, and dads have been left out of the equation way too much. We need to start with joint custody, and then we need to do what's the right thing. Joint custody is not going to be the right thing every time. And so I'm going to ask you to trust me that all I care about is getting good law. And until we passed it through the Judiciary 7-1, I didn't get anything from them. And you know how this works. If you will vote to support me, we will continue to work with them to get the very best law we can get. And getting this through House Committee and through the House is a very tall hill to climb, which will, of course, take amending regardless, and will mean it will have to come back here. So I would very much appreciate your support today in passing this bill, that we need to move forward. It may not be perfect yet, but it isn't because I haven't tried to make it that way. But we will continue to do whatever needs to be done to do the best for families and for the children in Arkansas who need both of their parents. And I'll be happy to take any questions.
Before we take questions, I want to recognize Senator Eddie Joe Williams. I don't have good eyesight, but I think that's who that is. Now we'll take questions. Any questions for Senator Clark? Senator Chesterfield has a question.
Thank you, Senator Clark, and thank you for the bill. I do take exception to and I know it probably affects men more, but it affects women as well. And it is particularly troubling because one of the things I'd like for you to begin to work with me on is addressing the ad litem part of this. Because so many times the ad litems don't respond to either parent in a timely fashion. But we are going to have to try to do something so that our kids are not made footballs between their parents. Would you agree?
Absolutely, and I'm glad you said that instead of me, Senator Chesterfield. I hope that the head of the ad litems was watching and listening to you when you said that.
Any other questions? Senator Irvin.
Thank you, Senator Clark. Just quickly, is there a certain section that they're wanting it to be amended, or can you highlight where the issue might rise or what you anticipate might needing to be amended? If you said that when it goes to the House, or if it gets voted to the House.
And we have folks that think it's fine the way it is. I'm not a lawyer. I just want the best law. One is, they say here on page 1, line 26, the presumption that joint custody is in the best interest of the child may be rebutted. They say that this presumption itself is too strong, that a presumption is so strong that you have to have overwhelming evidence to disprove that. Now, I have other attorneys, including those on board with this, who say that's not true, but nevertheless, I listen to these very serious attorneys of the Bar Association, and I'm paying attention to them. I'm just saying, bring me something else other than this. But that really has been their main contention, is that right there.
Okay. Thank you. Appreciate it.
Many of the other arguments they presented, they never presented to me.
Question.
Senator Flowers.
Thank you. Yes. Isn't it true, Senator Clark, that in presenting this bill in the committee, there was clear communication to you concerning this bill that beyond that line 26, 25 and 26 that you referenced, is line 27 and 28 that the bar and the judge who spoke against the bill had serious difficulty with. It says, if the court finds by clear and convincing evidence that joint custody is not in the best interest of the child, that's when you say that presumption may be rebutted. And the point they were making was that you've changed the burden of proof in these type cases. In the cases that come before the family law judge is generally beyond or preponderance of the evidence, which is less stringent than clear, convincing evidence.
Yes.
Pretty much have to have experts in there to overcome this rebuttable presumption that you say has to be found by the court with clear, convincing evidence that it's not in the best interest of the child. Is that true? Didn't you understand that it was the burden of proof that you're changing when other parts of a divorce case or issues dealing with family law is simply preponderance of the evidence, which is just greater weight of the evidence?
Yes, Senator Flowers, you are correct. I answered the question to the best of my memory, but you are correct. And we actually, from our meetings, had actually offered the Judiciary Council a chance to change that. They had not. And I do not think that changing that to a preponderance will be a problem, actually. They just had never offered language to change it to a preponderance of the evidence. But yes, that was another sticking point, Senator Flowers, and I appreciate you bringing it out.
Well, my question to you is, why wouldn't you today pull the bill down until you read what they have sent you to understand what the contentions are and would maybe make your bill better? And you read from the Judiciary Bench book, that's not the law. That's just some advice that's written up for judges to have a starting place. But before the court come the parties and lawyers that argue what the law is and present to the court what the law is. Would you agree to pull your bill down so that you can get it together with the Judicial Council, lawyers that are involved in these type cases? Because to me, what you failed to say and what you didn't read in the bench book, but the beginning start of that 913-101 that you want to change says that the court should be considering what is in accordance with the welfare and best interest of the child. And the language that you have in this bill is so tight. To me, as a family lawyer, I just don't see why we would be taking out the welfare and best interest of the child as the focus, as opposed to you wanting joint custody of the parties so much. It should be about the children, not about fathers and mothers.
Point of order.
If you want to speak on the bill, we can do that, but this is question time.
I asked him a question, which is, why won't he pull it down to work with Judicial Council on getting some language that is less confusing, less contentious, and better for the welfare and best interests of the children?
Okay, let's get an answer to that question.
Thank you. I pulled a bill down Thursday. Pull bills down all the time. This body's very well aware of why I'm not pulling this bill down. I have met with these parties for 18 months and was offered nothing till today. I will work with them. I will take as long as it takes. But except I move forward, they have not demonstrated that they will work with me. And I would appreciate your confidence in me in allowing me to move forward and putting the pressure on them.
Any other questions? Senator Elliott has a question, then Senator Stark. Senator Elliott's recognized.
Thank you. Senator Clark, do you have the proposed amendment with you from the trial lawyers?
No, I have not seen it.
Oh, it's not come to you yet?
It has come to me, but I was driving.
Oh, okay. Do you have it somewhere on one of your devices or anything like that? Do you have it anywhere on one of your devices or anywhere?
I'm sure I am. They told me that I have it. Yes.
Yeah, just because, I mean, I understand, that when you get something going, you want it to go, but it would be helpful, even if we delayed for a bit, we could hear what the suggestion is, the amendment is, if we could just see that. Because that would make some difference in my thinking about how I want to vote on the bill. What I know it is you're entertaining about adding to the bill. So that's why I'm asking.
I didn't hear a question.
No, quite. Yeah, okay. Senator Starks, then Senator Rice, then Senator Hendricks. Senator Starks.
Thank you, Mr. President. Senator Clark, I just want to ask because I don't know. You mentioned that the law was changed in 2013, 8 years ago, but that the bench book had not been updated since then. So
No, go ahead. I'm sorry.
Can you tell me then who is it that updates it, or how often is it updated as far as, I mean, if we pass this bill and we add this new language, is that up to the Bar Association or Judges Association, or who actually does this to give it the advice?
Thank you for the question, Senator Sturch. This was last updated in 2018. So it had been, and it refers to the law passed in 2013, that we had passed a law that says joint custody is favored and gives the law the number of the law, and then says, however, twice case law indicates that joint custody is not normally favored, and then says joint custody or equally divided custody of minor children is not favored in Arkansas, in spite of the fact that the law had been passed in 2013. And then the email that the Senate Judiciary Committee received came from AOC that they had revised it. So I'm assuming AOC is the one that does that.
Senator Rice, then Senator Hendren.
Thank you, Senator Clark. You've explained it very well, but just in case we're distracted sometime, everybody here can understand. We had a good, lengthy debate on this in Judiciary. Doesn't mean that we're right on everything, but it was covered as good as I could have hoped for. And as you said, a 7-1 vote. You have explained, and this is not the first time, that last-minute tactics have been waited to be used in legislation that you brought forth to help children and families. And while I know you don't disclaim that judiciary wants that too,
Senator,
do you state again here that do you see this as the only way to continue with some pressure to get something that they would not do with you before?
I was completely stonewalled before, yes.
I would appreciate people's trust in Senator Clark. I've listened to it, and I believe he is very well justified. Thank you.
thank you, Senator. I just want to point out that when we're having questions, let's ask questions. If people have more than a question, you can come on down to the appropriate time. Senator Hendren.
Thank you, Mr. President. Senator Clark, this is a tough one, and I was one of the 7-1 that voted for this, but I still have a couple questions because I know a big factor for many of us was the book that you showed where the courts had basically said, the legislature says this, but we don't care. You just mentioned that they had changed that, and what did they change, and when did they change it? And was it a result of that vote out of Judiciary Committee?
It was a result of the vote out of Judiciary. The email went out to all of us. I understand the volume of emails we get, so I'm not assuming that everyone read it. And they noted, having watched the committee meeting, that they apologized and went back and they had revised it. And I can't tell you all that was revised, but I can tell you that those two paragraphs are still the same. It is my memory that the third one is not there. But the second one, however case law indicates that joint custody is not normally favored, is still there.
Okay. We all have our personal experiences with how this has worked and how it hadn't. I guess what I want to know is, worst case scenario is the legislature now is raising the bar to fairly heavy level for not to have joint custody. And one of the concerns that was brought to me, what about a poor family, a poor couple that's divorcing in a situation where the husband has been abusive? Is it going to be too hard for that husband to not enjoy joint custody in that situation under this proposal the way it is now?
And Senator Hendren, that is a valid question. I think it's also a valid question for the dad who wants joint custody currently. What kind of burden that he has to bear, and does he have the money to hire that attorney? Like the one man said who called me who did have money, I'm a unicorn. And so I'd like to deal with that. And that's what I have asked them for all this time. And I don't think anyone here doubts my sincerity. They can tear this up and start over because we want good law. And that's all. I've asked for their help from the beginning. I said, if this is not right, but their members who called me because they had been contacted against this law, when we talked, they said, no, we need stronger law, and we have judges who aren't following it, and said they would go back and call the Bar Association and say, y'all need to work with Senator Clark in order to come out with a better law, not just to oppose this.
So you think there is a way, working with them, you can ensure that both those interests are protected without setting the bar to a point where that situation I described would not occur?
I absolutely do, Senator Hendren. We, on child welfare, y'all are aware of how many child welfare bills we have been passing per session. I sit week after week with every party, the ad litem's, DCFS, parent council, I can't remember, someone from the governor's office, et cetera, et cetera. And sometimes on a 2-page bill, we will fight week after week after week over 2 words, but we finally get it right if we're determined to get it right. And I am determined. I just haven't had the partners yet. And that's, I just need the partners.
Senator Hammer.
Thank you, Mr. President. Senator Clark, how long have you been working on this?
I picked it up, this failed in House committee 2 years ago, and I picked it up after that.
Did you have any interim study proposal meetings or any meetings between then and now that this subject was before committee for discussion?
Had no discussions with the legislature. I did sit down with legislators, with the proponents of the bill, and with the Bar Association to discuss the bill, and especially with the Bar Association since they had opposed it. I do not believe Judicial Council opposed it last time, or they would have been invited. But for any suggestions they had for improving it and changing it.
And subject to what the amendment says that you haven't had time to read, if it deviated away from where the bill is currently, would it stop you from going ahead and running the bill anyway because you believe the content of the bill as is what you've been pursuing for the last 2 years?
We're going to pursue joint custody as being favored and in a way that it can't be ignored. I do believe that there is a way to sit down and get this written, if they do not think it's correct, to get it written where it is correct. Sometimes it's hard, as we all know, to separate the dramatics and the theatrics from what is real, but they do seem to be sincere, and so I sincerely say, then show me what it needs to say.
All right, thank you, Mr. President.
Any other questions? Senator Hickey.
Senator Clark, let me ask you something. Would you be, based on what you've said, would you be willing to pull this down for a week, because I know they're watching, and let them get this the way that you feel is correct, and then if they don't, just bring it back before this body. Could we try that? Because I hate to pass something out of the Senate that we know is basically you're sitting here saying that it's not exactly right. Would that be too much to ask?
Senator Hickey, it's coming back to the Senate.
I understand. I would just rather it be right when it leaves the Senate.
I would rather it be right when it leaves the Senate too. I have, we've had that discussion on another bill, not necessarily you and I, but I and some others. And I've been quarterbacking this bill, and I would have much rather that it was what you said. This is the better path. But I do appreciate the question. Y'all don't have to send it, but
continue. The only thing is you've kind of phrased it, well, if we trust you, well, which I trust you immensely, but I hate to send something out of the Senate that's not right. So that's the bind that I feel like I'm in at this point. So,
well, Senator, like I said, there's two questions here, and we're early in the session. There is the question of child custody and joint custody, and there is the question of how we, because a lot of us are senior now, of how we work. And I, not just on this bill, but on every bill, when somebody comes to me with a bill, I say, here's what I do. We get it written, we sit down with the proponents, and then we sit down with the opponents. Always. We sit down with the opponents and we say, what do you not like? What's wrong with it? And often they point out things that I would have never seen. And we fix everything that we can fix. And once in a long, long while, we actually come up with something everybody agrees on. Nope. But at the very least, we come up with something that's much better. And, I'm not new at this. And then we come and we get to committee, and then a lot of times we end up amending it there. But when you get one argument, okay, when you get one argument here, when you're meeting in meetings, and then you show up in committee and you get completely different arguments, and y'all get called with completely different arguments, that's not, we're used to it, but that's not the way it ought to happen. And the fact is, I have been upfront with them. I have been upfront with you. I will continue to be. All I want is a good bill. I'd rather tear it up and throw it away than come out than leave here with bad law. And I hate to ask you to do this, but I am asking you to do this because they think that they can just stonewall, and maybe they can't. That's what y'all have to decide.
Thank you, sir.
Any other questions? Any other question? Anyone wish to speak against?
I do.
Senator Flowers is recognized against.
Thank you. I won't be long. I'll just point out some things. I think, like Senator Hickey suggested, should be held until he at least reviews what has been offered by members of the bar that practice in this area of law, as well as the Judicial Council. But to change up burden of proof, have two different burden of proofs in divorce cases, and not only in divorce cases are we talking, but this language that he has in his bill clearly states that in an action for divorce or an action to modify a child custody order. So we're talking about people coming back to court that are already under a child custody order that's been decided by a court that ask for it to be modified. And so I can't help but think about the influx of cases that will be filed requesting modification based on this change in the law, which I think is overbearing. I think what I heard from the sponsor of the bill is his dissatisfaction, as expressed by some fathers, with some judges. And he specifically referenced one judge with his written order. Judges' orders are subject to appeal. And before they even get to that point, they're impressed with argument of counsel for both parents. And it's the duty of the lawyers to bring the law, the current law, and the accurate law before the court, the law that the court should apply to the case. So to say that some lawyer said that judges are not getting the law right, I can't even imagine a lawyer saying that and hasn't taken a judge's order up on appeal if the law is wrong. I think we're going down a dangerous road when we are tying the hands of courts to decide what is in the welfare and best interest of children, young children, minor children we're talking about. And he already said parents can feud and fuss over custody of the children, how much support they're paying. A whole bunch of issues are involved when you talk about child custody and parents and why they fight over that issue of custody. So I would ask again that Senator Clark pull the bill down, take it back to committee, work on it with the persons who have offered him some difference and some variance that would make it a better law. But one other thing I'd note, Senator Rice suggested since it got 7 votes out of committee, it must have been hashed out. Well, I sit on another committee, and during this session, I've seen a bill come out of a committee with 7 votes. And then when you got to the floor with the bill, those 7 individuals didn't even vote for the bill. So I'm just wondering, what is the motivation here? Just to get something passed because you're upset with some judge and you're trying to stand up for some constituent or several constituents that have come to you complaining about judges and about the fact that they didn't get custody of their child? That's not appropriate. When we're talking about children, we should have a higher level of understanding of the ramifications of the things that we do and put in these bills. So I ask you to vote no for this bill. Thank you.
Anyone wish to speak in favor of the bill? Senator Irvin and Senator Irvin.
Members, I think this is more than just about dads. I think it's about moms and dads and children and families. And, you know, when I read this bill, and I asked the question because I wanted an honest answer, and Senator Clark gave us an honest answer. You know, I'm not sure if the amendment is actually something that, you know, is needed or not. But I can make that judgment, and he was honest in his answer to me. So I'm for this. I trust that Senator Clark, if it needs to change, it's fine. But in my reading of the bill, you know, and again, and speaking with some of the attorneys that I've talked to on this bill, I think it's really talking about making sure that children have 2 parents involved, if at all possible. And if somebody is financially not able to challenge this in court, that is where I think the issue has arisen, and where this bill has come from is a place where you may have a dad or you may have a mom that just doesn't have the money to fight this in the legal justice system. And so we need to make sure that our laws don't allow for somebody, if they have the money to be able to fight for custody of their kids, they get custody or not, just because they have the money or the means to do it. I'm not sure if that's where I want to be. I want to make sure our laws are equally applied, and it doesn't mean that you have to be super rich to take advantage of a situation or being able to fight for your rights as a parent. So, you know, I trust in the way that the language in Section 2 says, a court shall consider the best interest of the child when making a child custody determination. The evidence is going to be before the judge. I think presuming that a child is better off with 2 parents in their life is probably the best place to start. Clearly, there's going to be evidence one way or the other if the judge sees differently and that it's an unsafe environment for a child to reside or be in. But I appreciate your answers to the questions. And the reason I asked the question was because I wanted an honest answer, and I appreciate you giving it. I'm for the bill. Thank you.
You always speak against. Speak for. Senator Mark Johnson was next, and then Senator Blake. But go ahead, Senator Blake Johnson, if it's okay. Senator Johnson & Johnson.
Members sat through the testimony, and I'm pretty much a black and white kind of guy, and was told through witnesses that the law is gray. Well, I guess on a sunny day, you can see gray and blue, but there's a lot of evidence in past history that children have not gotten both parents and have been weighted one way. And I think Senator Clark has tried to correct that, and at a request at the last minute, not even on paper here at the floor, but in testimony. I'll tell you the 3 levels of the burden of proof. There's a preponderance of evidence, which is you might have been convicted of something with preponderance of evidence, and it might be weighted against you in this custody case. And this is asking for clear and convincing evidence. Well, that's for a child. The preponderance of evidence was on another case. But if the person is clearly unequal, then a judge can see that with clear and convincing evidence. There's also the 3rd level, which is the highest level, which is beyond a reasonable doubt. Well, it was said in testimony that this would require more expert witnesses. Well, I've talked with attorneys that never brought an expert witness to the court, and beyond a reasonable doubt had a person convicted of murder or other things without that. So to say that this is going to cause a great uproar and cost in the process is not it's not true. It's just an argument. But whether the senator and makes amendments further down the line, I think he's made a convincing argument, and I think there ought to be equality in the law for both parties for the betterment of the child. I'd appreciate a good vote on this.
Anyone wish to speak against? Anyone wish to speak for Senator Johnson, Mark Johnson?
Thank you, Mr. President. This bill, it seems like, remember that movie, Groundhog Day? And that's tomorrow, by the way, Mr. President, where the guy wakes up in the morning and it's like the same day all over again. I really thought this had been taken care of a few years ago. I've had several parents speak to me about the issue in general. Of course, anytime it's in general, it's like that saying about being average. If you got one foot in a bucket of ice water and the other in a bucket of boiling water, then on average, you're about right. Well, these are people's lives and children's lives that we're talking about here. It's come down to really, there are 2 issues about this bill. The first one is the simple one that has taken a lot of work over several years, and Senator Clark is carrying the ball this year and doing a great job, in my opinion. But it starts out with something that many of us feel fundamentally is that, as to the extent we can, a 2-parent coalition, preferably married and in the home, but as we know, in this day and time, certainly that doesn't always happen. But even if they're divorced, it's best when parents work together for the good of their children. But to the extent we can have both a mom and a dad involved in parents' lives, and this is to not in any way disparage the wonderful single parents that have done a great job with their kids. And some of us with both in the house, maybe we failed in some instances. We're all human. But systemically, we've got to set up what Senator Clark has called a presumption. We have to presume that it's best if you have two parents. And that's what this bill at its core is about. The second issue is one of separation of powers. We don't apply the law, but we do make the law. And it's clear that in this instance, we've had situations, certainly not all judges. I wouldn't dare criticize all judges of that. And I certainly respect Senator Flowers as a lawyer who practices in family court and seeing these things up close and personal. But it's important that we make sure that we, the General Assembly, are not ignored and blown off. And if we have to go back and make it a little bit tighter, a little bit stronger, and a little bit clearer, then I think that's what this bill does. And I appreciate Senator Clark and Judiciary Committee, everyone that's worked so hard on it, and I would appreciate a favorable vote on the bill. Thank you, Mr. President.
Just point out, please refrain from entering the well when another senator is at the rostrum. Anyone wish to speak against? For? Senator's closed. Senator's closed.
Like to close, Governor.
Senator's recognized.
I didn't spend much time talking about the bill. I did not promise in Judiciary Committee, I didn't make any inference that I would amend the bill when I passed it out of Judiciary. This bill, if passed the way it is, makes the law better than it is now. There has been some talk that some people would be harmed. More people are harmed now. More children are harmed now. More families are harmed now than could possibly be harmed the other way. I only made the statement I made because after leaving Judiciary, I called them after they had stonewalled. I reached out and said, if you're serious, show me. Give me something else, because all I want's good law. It's not that I don't have good law, but all I want's good law. So I didn't pass this out of Judiciary promising to amend anything. I came here today to tell you that I have offered to them, with their reservations, that if they've got something better, bring it to me, because that's all I want. But we have a great disparity when it comes to fathers. And I will close with this. A young man, right after the Jonesboro school shooting, a young contractor walked into my store, a friend of mine, and he said, Alan, he said, I hope this never happens with my sons, who are about 6 and 3. And I said, Aaron, this will never happen with your sons. And he said, how can you be so confident? And I said, look at the record. And the record is still the same. Every one of those school shooters, almost everyone, not everyone, but almost everyone did not have an active father in their lives. Now, I want to tell you, I'm not discounting mothers. You know, when I was running, one of the biggest decisions I had to make during my campaign, I went down and sat with my mom and dad, but it was my mom's advice I wanted. So I'm not discounting moms, but I'm telling you that we have a great disparity in our system when it comes to dads, and there's a reason why we want to start with joint custody. But I have promised you that I'm going to work to be sure that we get it right, and I would appreciate a good vote. Thank you.
Madam Secretary, please call the roll.
Ballinger. Beckham. Bledsoe. Caldwell. Chesterfield. Clark. Davis. Dismang. Eads. Elliott. English. Flippo. Flowers.
No.
Garner.
Yes.
Gilmore. Hammer. Hendren. Hester. Hickey. Hill. Ingram. Irvin. Blake Johnson. Mark Johnson. Letting. Pitch. Rayford. Rice. Sample. Sample. Stubblefield. Sturch. Sturch. Sullivan. Teague. Tucker. Wallace.
Senator Sample, I don't see Senator Sample. Anyone wish to change their vote? I see none. Cast up the ballot. 31 yeas, 2 nays. The bill is passed. Transmit to the House. Senator D. Wallace.